Good day, and thank you for joining our webinar, 90 Days to 2020, California Consumer Privacy Act, Are You Ready? Brought to you by Aon, Stroz Friedberg, and BakerHostetler. Our program today will last 1 hour and is approved for 1 hour of CLE credit in California, Florida, Georgia, New York, Pennsylvania, and Texas. California, New Jersey credit is available via reciprocity. Credit is pending in Illinois and Washington. For all other states, attorneys can receive a certificate of attendance and electronic materials so they can file directly with their CLA credentialing entities. This may need be subject to your state bar rules. During the course of the webinar, we'll share 2 codes that you'll need to enter into a brief CLE questionnaire immediately following the program's conclusion. Once the webinar has ended, please look for a small pop-up on your screen. Click Close for your CLE quiz to appear in your browser. Please make sure to answer all questions if you'd like us to submit for CLE credit on your behalf. If you have any questions regarding the presentation, you can type your presentations into the bar on the right side of the screen in the questions area. We'll try our best to answer at the end of the program, time permitting. If not, we'll follow up with you after the webinar to answer those questions. We'll provide our contact information on the slides and again at the end of the program so you can contact us at any time with comments, suggestions, concerns, or questions. We'll send an email to everyone the next day or two with a link to the recording of the webinar. This webinar is for informational purposes. It's not intended to constitute legal advice or create an attorney-client relationship. So with all of the administrative out of the way, let's go ahead and begin. Who are we? I will let my co-panelists introduce themselves. My name is Alan Friel. I'm a partner at BakerHostetler, resident in the California offices, and I practice in the area of consumer-facing privacy and consumer protection. For the last year, I have been living CCPA 24/7, helping clients build out information governance programs that will enable them to be CCPA ready on January 1st or as soon thereafter as practical. Heidi and Michael?
Hi, my name is Heidi Wax. I'm a vice president with Stroz Friedberg, an Aon company. I am based in our Washington, D.C. office, and we are not practicing attorneys at Stroz Friedberg. We're a consultancy, not a law firm, and we have been helping clients with the nuts and bolts of operationalizing data mapping, data discovery, and the various types of programs we're going to be talking about over the next hour.
And this is Mike, colleagues with Heidi. And yes, Heidi said we're not lawyers, although both of us have come from a legal background. I've been outside counsel in privacy and security, among other areas. I've worked as an in-house attorney focusing on both privacy and security, worked on GDPR compliance and other compliance and response issues internally. And now I'm here, and while we're not practicing, we do draw on that background a bit to understand how the nuts and bolts, as Heidi put it, fit into the frameworks created by CCPA and other requirements. And I think pride ourselves on being able to speak to technical and non-technical worlds.
Great. So Heidi and Mike, you're going to kick us off here.
Sure. So first, a brief overview of the CCPA, a snapshot of the legislation. It is effective January 1, 2020, although there's a delay in when the AG enforcement starts. It regulates both privacy and data security. So there are elements in the legislation that address both data privacy and cybersecurity, and we're going to talk about that a little bit later in terms of the security specifics. Consumers have certain rights regarding their personal information. So the rights of access, portability, and deletion, right to prohibit the sale of their personal information, and there are specific exceptions and carve-outs for individuals under the age of 16. And businesses may not discriminate on the exercise of rights. On the security front, businesses must implement reasonable data security, and we're going to talk a little bit about that later, what that means. How do you interpret reasonable data security? This isn't a significant change from the current California data breach and security requirements, although this legislation includes a private right of action and statutory damages for individuals affected by certain types of data security incidents. So there's a possible delay in enforcement of some of the privacy provisions. The California Attorney General must promulgate regulations by July 1st, 2020. But the AG cannot bring enforcement actions until 6 months after the publication of those regulations or July 1, 2020, whichever date is sooner. This extension, however, only applies to the AG regulations and enforcement. It does not apply to the private right of action on security requirements. So those provisions become effective January 1, 2020.
You know, and noting on this, Heidi, you know, a lot of clients have asked, is this a safe harbor? Since the proposed regs haven't even come out yet, they're going to come out sometime this month, it's probably pretty certain we're going to be into very close to the full 6-month delay in enforcement. But the question remains, what does that mean? And if you read it literally, it just means that the Attorney General can't commence an enforcement action during that period. It does not say that he can't commence an enforcement action the day that tolling period ends regarding noncompliance that occurred during the tolling period. And then, as we'll talk later, there's a 30-day there's a notice and a 30-day opportunity to cure. But I co-hosted a fundraiser for the AG a couple of weeks ago, and several of us asked him point blank, is this a safe harbor, and how is the cure going to work? And he refused to commit to it being a safe harbor. And with respect to the cure, he basically said he doesn't think it's very likely that there would ever be an ability to retrospectively cure a non-compliant situation, because you can't undo the infringement of somebody's fundamental rights. So I would caution people if they think that it's really a true 6-month delay to the implementation of the act.
I think, and thank you, Alan, that was very helpful. And I think related to that, you know, there's this 12-month look back. So consumers have to be provided information about what was collected and used on them over the last 12 months. So in theory, that although the law is effective January 1, 2020, companies and organizations need to begin to be able to answer these questions dating back to January 1, 2019.
Okay, this is Mike. Thanks, Heidi. So obviously one important thing to understand here when you're contemplating how the law does apply to you and your business is to understand the definition of a consumer, since the law applies to personal data of consumers. And I think the term consumer can be a little confusing. It could suggest that this applies in a business to consumer B2C context. You've got an individual who's purchasing goods or services from a business, but that's not what it means. This comes from the California State Tax Code, the definition of consumer. And you can see on this slide, it's really pretty broad here. Individuals in the state for other than a temporary or transitory purpose, individuals domiciled in the state but outside the state for a temporary or transitory purpose. So really, this is it's individuals. It is a good way to understand it. And what that means, one of the central debates and questions that's persisted throughout the life of the the proposed law is what does that mean for employee data that your company collects as an employer? That's data of your employees, whether does full or part time doesn't matter, and applicants. The companies typically have quite a bit of really sensitive data on those types of individuals. So what does that mean? There was some thought maybe they're not really consumers. It's clear that they are, that data is covered. However, there is it's under Assembly Bill 25. The law was amended. This is a pending signature by the governor for mid-October. But under this bill, the applicability to data of employees, applicants, etc., would be delayed until the beginning of 2020, January 1st, 2020. So that's something for companies, certainly. I think something we've definitely seen amongst clients is that generally data that they have as an employer is a bit more of a black box than the data they have as a provider of goods or services. They've got some understanding of their consumer relationships, but their HR type relationships, the data they have, where it goes, when it goes, different places, they've done less work understanding that. So I think that'll be helpful, but nevertheless, it is in play a year out. There are some exceptions to that, so it's not a wholesale exception from the law. So you don't have to worry about for the year subject access requests, which we'll talk about. But what you do still need to do is provide notice to your employees under the law and your applicants of what data is collected and how it's used. So keep that in mind when thinking about the law. You don't have to go whole into your employee data, but there are some provisions that still apply.
Yeah, we'll be watching this week to see if he signs those amendment bills. Interestingly, there's a new ballot initiative that's been filed that would significantly strengthen consumer rights, particularly as it relates to advertising. But one positive in it is it would make these changes for HR data and B2B transactional communications permanent. So we'll have to also keep our eye on the whether or not the ballot initiative gets enough signatures to go on the November 2020 ballot and how it's polling. But things continue to evolve.
Yeah, it's very interesting given, I think, how much change that would mean. Alan, one question I had for you is we talked about that when we read through the definition of an individual, of sort of a consumer, you saw the qualification around temporary or transitory purpose. Do you have a sense of what that means? Is there any sort of source of law people could look to understand when someone might fall in or out of the law based on that term?
Well, I mean, it's tied to the revenue code. So the test is if you pay state income taxes in California, you're a consumer. And you're still a consumer, even though the scope of the act may be carved out or carved back with respect to certain of your data collection circumstances, such as when you're acting as an employee for another business or or for a business. The challenge, of course, is going to be the verification. How are you going to determine if somebody is a taxpayer in the state of California at a particular given time? Certainly it would seem that you would not be entitled to a copy of their California tax return because that would be sort of counter privacy protective. It may be as simple as somebody verifying or attesting under penalty of perjury that they qualify. That is one of the few things that the Attorney General is mandated to issue regulations on, is to what extent a company must or can verify both residency and that they're the actual data subject. There is one of the amendment bills does add a reasonableness standard to the verification provisions, So if the Attorney General does kick the can down the road and not give us very meaningful verification regulations, we can at least rely on a commercially reasonable standard, something that the current statute does not provide.
Well, thank you. So then our next slide here that's up on the screen, I talked previously about the law being applicable to personal information of consumers. We talked about consumers, so here's personal information. If you are familiar with this concept from, say, state data breach law in any of the states, this is quite different, is more in line with something like a GDPR or a HIPAA, or something that's really thinking about data in terms of the identifiability, rather than being more focused, as many of the data breach laws are, on identity theft and other types of issues, thinking about certain types of data as being in scope, rather than identification being the issue. So here you'll see right now, and I'll explain the brackets around reasonably in a moment, that personal information that identifies, relates to, describes, or is capable of being associated with a particular consumer or household. And so that can bring in a very, very wide swath of information, either that just directly identifies someone, or that someone could use, piecing together with other information that's available to say, oh, okay, I know who this person is, and I know what's being referenced. Alan, could you talk about the Assembly bill and the reasonably qualifier? Because I think that is important to kind of understand what kind of data is getting at, and how data might or might not be in play for the law.
Yeah, I mean, I think it's helpful. It's still incredibly broad, right? But I mean, anything is capable of being associated with a consumer or a household. So this helps that it puts this reasonableness standard. In some use cases, that may help a little bit. I think one thing that's key, and I just see a question coming up from someone about, is this a common or textbook definition for personal information? And it's not by American standards. It is far, far, far broader. I mean, we have traditionally considered pseudonymous data in the United States not to be PII or personal information. We've not regulated it in the same way. Pseudonymous data is specifically regulated, and in the next slide I'll point out some examples of that. But I think the even more important about 874 is it changes the definition of publicly available. An exemption to the definition of personal information is publicly available personal information, and that currently defined as personal information that is published and publicly available by the government, not the phone book, but by the government, and it's used in the context that is compatible or for the same purpose that the government made it available. Well, the problem is the government doesn't make property records available for real estate agents to solicit people to sell their house, or marketers to send welcome to the neighborhood packets. And so there's a lot of concern about that. 874 would get rid of that government purpose limitation. And that's really an exception that you could drive a Mack truck through. So that would mean that if you can find a government database that has the personal information that you don't want to delete or otherwise provide consumer rights on, then arguably, or at least literally, based on the 874, it's out of scope. It's not personal information at all. Now, how many people are actually going to go and tie specific pieces of data to their location in a publicly available government database? You may not care. It may be easier just to provide the consumer rights, but I can bet that a number of data brokers are going to be able to flag the data that they're selling as publicly available to give it a greater level of exploitation and commercialization than would otherwise have applied if 874 didn't exist. So let me just talk a little bit more about what our personal information. One of the unique things, and there are similarities and differences between CCPA and the European GDPR. One is this concept of categorization. The CCPA is all about its categories. There are 11 enumerated categories of personal information. There are 8 enumerated categories of business purposes. And then there are a bunch of other things that you're supposed to categorize, but there are no enumerated versions, or categories rather. And so when you are providing consumers notice, either in the annual posted privacy notice or in response to specific consumer inquiries, you have to break down the personal information into these 11 categories. And as we're talking about what is personal information, you can see some of these are things that we normally might not have considered as personal information, such as unique ID, IP address, ad ID, and so forth. And probabilistic ID is another example of PI under the Act. So I mentioned excluded is publicly available, and that is hopefully going to be expanded. There are also carve-outs. Protected health information governed by California or federal health information laws is carved out. Data, to the extent it's regulated by Gramm-Leach-Bliley or the California version. As I mentioned, AB 25 would temporarily carve out some of this employee and business communication data for some, but not all parts of the statute. It's worth noting that the financial institution carve out does not include a carve out of the data security and private right of action, but the PHI, the HIPAA carve out, does. There's also a carve out for de-identified or aggregate consumer information. As is the law currently provides, there's a section that says nothing in the Act shall prevent a company from being able to create and continue to use this type of de-identified or aggregate data, but it's not carved out of the definition of personal information. AB 874 would fix that and clarify that it is. One of the consumer rights under the CCPA, and one that's most misunderstood, is this concept of do not sell, the ability to have transparency regarding and exercise control over the sale of your data. And most clients, until they dig into the definition, intuitively believe, oh, well, we don't sell consumer data. But if you look at the definition of sale, it's any making available of personal information to another business or a third party for valuable consideration. And for the lawyers on the call, they will recall from their first year contracts law that any commercial understanding has consideration inherent in it. And so unless the Attorney General's regulations take a more restrictive view of other valuable consideration, basically any commercial making available personal information is going to be a sale unless it meets one of these very narrow specific definitions. And to make that even more clear, the proponents of the new ballot initiative are expanding this to make it even more clear that any kind of commercial transfer is a sale. So what is not a sale? Is not a sale if the consumer explicitly and intentionally directs the transfer. For instance, tells a manufacturer, hey, pass my information along to your local retailer in Dunwoody, Georgia, and so that I can be contacted and learn more. Sharing of the identifier to ensure the opt-out. Well, that's pretty narrow and it makes a lot of sense. Here's the big one. If it's with a vendor that qualifies in one of two ways as a qualified vendor under the Act. There's the definition of service provider, and then there is this strange exception from the definition of third party. They both have to be for vendors, but they have different requirements. Most people are going to want to be a service provider because it provides more flexibility, including some ability, to the extent not unreasonably expected, to use the data for their own business purposes, whereas the third party that's exempt from the definition of third party can only use the personal information to perform the services for the business. Both require contracts. This exempt third party requires a separate certification, but one way or the other, one of the big exercises through the course of data mapping is identifying vendors and anyone else that's a recipient of personal information and trying to categorize them in a manner that would exempt them from a sale. Because if you don't, then upon the exercise of a do not sell right, you have to terminate the ongoing access or disclosure or making available of that data. And in some circumstances, that could be disruptive. And there are not the same kind of exceptions to this as there are to the right to deletion. We'll talk a little bit later about some of the difficult use cases, including cookies, and how the Internet Advertising Bureau has assumed that interest-based advertising ecosystem disclosures are a sale, and has proposed a policy that would create signals to tie companies' do not sell rights to the cookies on their sites. Also exempt is a merger or asset sale disclosure but there's a requirement that the original collection purposes be maintained. And I had mentioned business purpose a couple of times, and this is essential because of this concept of the service provider disclosures. The service provider disclosures have to be where the vendor is performing services that support your enumerated business purposes, or to the extent that it's permissible, their own business purposes. And in your privacy notices and in the responses to consumer rights, you have to articulate the specific categories of business purposes that are at play. So this, again, is a little different form of data mapping than we did in the EU, because we have to worry about these categories. CLE code number 1, biometric information. Please make a note of that. And now I'm going to turn it over. I guess I'm still going, aren't I? Heidi, Michael, did you have any questions about that first tranche of slides?
Yeah, actually, on the last slide, Alan, I was wondering if you could expand a little bit. It seems like there are some limitations around the short-term transient use business purpose that could impact the use of third-party interest-based advertising cookies. You sort of mentioned that briefly, but could you talk about that a little bit more in detail and how it might impact the use of cookies for interest-based advertising?
Yeah, so the NAI, if you want to really look at a really great policy position about interest-based advertising and CCPA, look at the comments that the Network Advertising Initiative filed with the Attorney General's office, and there's some great arguments in there for why either interest-based advertising shouldn't be a sale, or that you shouldn't have to, you can't verify somebody's identity based on pseudonymous data, and you shouldn't collect more information in order to do so. All that said, as I said, the Internet Advertising Bureau has come to the conclusion that we're going to end up landing on this being a sale. And so they've created this signal-based system where there'll be two signals that a publisher will have to relate to the cookies on its site. One, I have given people notice of their do not sell right, and two, they either have or have not exercised it. If they have exercised it, everybody in the digital advertising ecosystem would have to only use the information the personal information that's coming from that publisher to the extent that they are performing first-party services for that publisher, ad delivery, ad measurement, but not, for instance, to take that data and put it up into a profile that benefits everybody else. Now, remember I had said service providers have to be subject to contractual commitments. There's not privity of contract in a lot of these relationships in the digital advertising ecosystem. So the way the IAB solves for that is to have a master agreement that everyone participating in the program has to sign, where they all agree to be each other's limited purpose service provider for purposes of this compliance program. The question, some people have argued short-term transient use, that's section 140D4, should provide an exception to enable you to qualify this as a service provider function. But if you look closely at it, sure, it is short-term transient use provided the personal information is not disclosed to another third party. Well, that won't work because you've got a lot of downstream sharing in interest-based advertising, and is not used to build a profile about a consumer or otherwise individualize a consumer's experience outside of the current interaction. Again, that doesn't work for interest-based advertising, but not limited to. What is permitted here, though, specifically, is contextual customization of ads based on the same interaction. So, in other words, I'm on a page and I'm reading an article on soccer. I get a soccer ad. That would be contextual advertising. That would be where the customization of the ad is based on my interaction with the content at the time, not across third-party services and across time. Does that help?
Yeah, very much. Thank you.
All right, let's dig into notices. So there's a few different types of notices that are required. The first is pre-collection privacy notices, and even if AB 25 passes, this will apply to employees. And this is a more truncated notice. You have to provide the categories of PI, remember those categories that I had listed, and the purposes for which the categories of PI shall be used at or before the point and time in which it collects the PI. So some of this is going to be easy. Apartment application, you can put this on the application form. Some of it's going to be more challenging. Point of sale machine at a cash register checkout, call center recording. So you got to basically look at every collection point and figure out how to put effective notice. Hopefully the regs will give us some guidance on what this means in the online world. Is putting that privacy policy link on the home page going to continue to be sufficient, or do you need some kind of more robust notice, particularly for things that might be more unexpected, like cookies? Are we going to see cookie banners, whether to comply with the pre-collection notice or to facilitate the do not sell opt-out as it relates to cookies? All this is still evolving. Then we have
one question I had on that was sometimes you'll hear someone ask, isn't there already a set of requirements on this in the form of the Shine the Light Act? Could you talk a bit about what is similar and different about that law? And in particular, I think people would like to know, if I'm doing CCPA, am I covered under the other law, or are they just a different set of requirements?
So the CCPA specifically does not preempt other California privacy laws. So CalOPPA continues to apply. That mostly says what has to be in an online service privacy policy, including specific disclosures about do not track signals and tracking across time and third-party sites and so forth. And then there's the California Shine the Light law, which says if you are sharing personal information with third parties for their own direct marketing purposes, you have to either provide them choice, which could be opt-in or opt-out, or you have to, upon request, provide a list of the companies that you disclose, not data subject specifically, but on an aggregate basis, personal information for direct marketing purposes, along with how to contact them. So there is some overlap between Shine the Light and the CCPA opt-out right, but they're not the same, and you'll have to continue to maintain both programs. In the same way that there's now going to be multiple opt-outs for interest-based advertising. The current About Ads opt-out by the DAA and the NAI is don't send me a targeted ad. It's not don't share my personal information with third parties to create profiles. And so it's going to get confusing that there's going to be multiple opt-outs. And then don't forget you've got your canned spam opt-out for commercial emails, and you've got your TCPA opt-out for text. So yeah, I think there's at least now 5 or 6 opt-outs that most companies are going to have to manage. And throw in a few more states, and we've got Nevada. It's got its own now do not sell opt-out that is different, much more narrow. But unlike California, where you don't have to have the do not sell link if you don't sell, the Nevada law does not give you, it reads literally that you have to give people the ability to opt out now of sales that you might decide to do in the future. But I think I've sort of digressed a little, so let me jump back to notices. There are two types of more general notice in addition to the pre-collection notice. One is your annual privacy notice. That's the 12-month trailing. It's the prior calendar year. That's what goes up on your website, and it is different than your privacy policy on your website now that's required by CalAPA and the Nevada and Delaware laws that copied CalAPA, because it has all this categorization, and it also applies to offline data collection, not just online. In addition, a specific consumer has the right to request data subject specific disclosures about your data practices as it relates to them personally. That has a 12-month trailing look back, but based on the date of the request. So whereas your general privacy notice is updated January 1 of each year and looks back to the prior calendar year, this would be 12 months trailing from the date that the request is received. And as you can see in red, there's a slightly bit more information that needs to go into the data subject specific request, one of which is the specific pieces of PI collected. That would be basically their access request. Now, interestingly, the law as it currently reads, although I don't have it up here, the specific pieces of PI was also part of what had to be in the general privacy notice. And that led to a lot of confusion. People would say, okay, well, obviously I can't give every piece of information, so this must be something more granular than categories. This must mean name, address, phone number, as opposed to your contact information or the category, as opposed to Alan Friel at 123 Main Street and my actual phone number. The amendment takes that specific pieces out of general notice, which would support the argument or the interpretation that specific pieces means the actual pieces. There's still some room for arguing against that, but since the access right would enable people to get the actual pieces, I don't see a whole lot of purpose in providing a second set of descriptions of the PI beyond the categories, although there are some clients that want to do that at the data subject information request level for a variety of reasons that are unique to them. So moving now to any questions, Michael or Heidi, about that before I move to consumer rights? All right, I'm going to try to get through this quickly because I know we want to talk about the data mapping. We've got about 20 minutes left. So this is sort of the GDPR-inspired rights. Unlike the do not sell right, this is the right to access and copy. You're entitled to portable copies. You're limited to 2 requests in the 12-month period. There are exceptions for if you have a California evidentiary privilege, like attorney-client privilege. Also, to the extent that another consumer's rights would be infringed, you can withhold or redact for those purposes as well. There's not, like there is in the European Union, a right to be able to make corrections, although many companies are just going to want to do that. And under CalAPA, if you do enable corrections, your privacy policy has to explain how the consumer there under that act, customer, can do so. There are also the right to delete, but it's heavily qualified with exceptions for retention purposes. In both of these cases, these are for verified requests. So again, I talked about the Attorney General is going to put forth standards for verification. If you cannot verify the identity of someone, you don't have to provide these rights. You have 45 days to verify, an additional 45 days to verify if necessary, and you can have up to 90 days to facilitate a request if there are conditions that make it such that it's reasonable. But for the most part, you should try to both verify and reply or disclose within the initial 45-day period. These are the retention exceptions. As you can see, there are some really broad ones here. If you've got an ongoing consumer relationship, you can retain, even if someone has canceled their account, you can retain for business record purposes, through the statute of limitations for claims, for debt collection, but the use has got to be limited to these retention purposes. So it doesn't mean that you can retain for all uses, such as trying to re-solicit them to become a customer again. I talked a little bit about already on a slide about this additional information rights. They're here on the slide. You can go back and look at that. And then we talked about the do not sell right already. So I'm going to advance that a little further beyond to get to Michael and Heidi to talk about, okay, this is a lot of what we need to do to facilitate these consumer rights. How are we going to do that if we don't know what data we have and where it's at? So Heidi and Michael, how do you go about helping a company prepare an information governance program that will enable them to access this information in order to describe it in the privacy notices and to timely respond to consumer requests?
Sure. Do you want to, I guess, actually advance the slides just a little bit, Alan, and we can begin talking about, yeah, there we go, one more. Yeah, so Alan sort of gave a great overview of what the law requires, and as he mentioned, how do you figure out what you need to do to begin to get towards compliance? And in order to do that, you have to be able to understand what you have and where you have it, in addition to some other details. Data mapping is a really broad exercise. It is not CCPA specific, although it is and can be the foundation for how you get to CCPA compliance. And oftentimes, data mapping and the analysis of the results of your data mapping exercise can serve a lot of different purposes, right? So the goals can be different for data mapping, and the goal can sort of backwards determine the scope of what you're looking at. So you want to think about when you're launching in to your data mapping exercise, what your end output goal is, And that's going to help you define the scope. And we're going to talk a lot over the next couple of slides about why it's important to understand and define the scope. Can you advance? Yeah, thank you. One of the things that Mike and I and our colleagues talk about very often is this issue of data mapping as a part of information governance, and information governance being a broader lens with which to look at this. And information governance is something that privacy professionals, privacy attorneys have been talking about for a very long time, and have had a hard time gaining traction and convincing clients and convincing large organizations to invest in the time and the effort that it takes to build out a really comprehensive information governance program. And information governance is broader than just what data are you collecting, where is it stored, and who are you sharing it with? It's more intricate than that, and it gets to a more technical level. Questions like, just because somebody has access to data in a specific repository or database, do we have a good handle on what an individual can do with their access? For example, do they have the ability to read or to write or to download the data that they're able to access? What are the applicable retention policies around that data? Not only is who is the data shared with, but is there monetary gain derived from that sharing? And again, this does speak to the CCPA piece, which is how can individuals begin to request modification or deletion of their data, right? So again, the information governance is broader, but if you're going to be digging in anyway, it might not be a bad idea to begin to think about these broader questions in addition to just mapping the specific data flows.
So as Heidi was referencing, your data mapping should be, to a significant extent, law neutral, in that your data mapping or your information governance program really generally is whatever metaphor you want to use, your foundation, your engine, your platform. It's what you've built that you use to understand and track your data, to understand what you're doing, what the implications of what you're doing are, where things are, what the relevant controls are. And when you've built that out, I'm not going to say it's easy, but it's relatively easy to pivot to complying with the various laws that are out there relative to trying to sort of ad hoc something every time. So on this slide, you'll see a bunch of categories that we have. It's not meant to really be exhaustive, or you could combine or break these up in different ways. But the point is that these are the many things that you want to think about when you're data mapping. And I think it's important to keep in mind, don't be confused by the term data map. You may have seen a literal data map of a nice flow chart, and it goes in different places, and there's icons. It's very visual and attractive. But really, when we talk about data mapping in this context, we're thinking about really building out a deep understanding, you call it inventory or whatever, of your data really over time and at all the key points in time. So, from where is it collected and where does it land, where is it stored through most of its retention at your organization, but also how things are dynamic, where it can move through your organization, where it can be offloaded, how it can be used, who would have access to it over time. As obviously things don't always sort of follow a neat linear plan. The data can come in and it can be stored in some particular place 80% of the time, but certainly it's possible someone else could come out, could go in, use it, store it somewhere else. So it's understanding all of that, which again forms the foundation of a compliance program for CCPA or GDPR or Nevada, whatever's next. It's clear that there's a lot of exhaustion out there. When we've talked to people about the CCPA, certainly, a lot of people have said, well, we just did this for GDPR, and now we're trying to think about how to do it. And then the next law comes down, and a way to sort of at least reduce that exhaustion is to first think about what is our program overall, and then think about how do we pivot on top of that to meet the particular requirements of each law. So here's a very basic view of how the process works. And the good scoping is really critical. And that's just what I want to highlight here, is we'll talk about this more in a moment, but data mapping, data inventorying is complicated, and there's a lot of different tools you can use. So understanding at beginning, high level, what do we do as a company? What data do we have? What are our systems like before you start drilling down, and to think about what is a smart approach in terms of the tools, the methods? How do we want to break this up? We could maybe do it department by department. We could do region by region. Depends on how your company, your IT infrastructure, your business is structured. But it's very important. If you just kind of start digging in, you'll realize very quickly it gets very inefficient. You don't have a goal in mind. So taking a 30,000-foot view, building out a good roadmap, a good project plan with defined sort of ways to tackle and break things up and tools to use, it's going to be an important pathway to success. So this highlights the point that I made here, and see if you could click forward once, you'll see the is that you have this big oblong box here, and it's got your different categories, and you've got the information on storage and sharing built into your program. So when you have a SAR, a subject access request, someone saying, tell me the data that you have on me, or I want you to delete this data, or whatever the nature of the request is, rather than sort of starting from the beginning and saying, well, where is this data and what do we do with it? You've got this built in, and you can sort of reference the categories that are relevant, in this case, storage and sharing. The question is, what are you sharing about me? What do you have and who are you sharing it with? And you can leverage the mapping and documentation you've done to say, here's the system, here's how data flows in, here's what we have, here's how we've identified that data, and we can respond back in a much more disciplined way than if we were taking each of these requests as a new project.
So I think, it's very easy for us to sit here behind our computers and on the phone and talk about, this is what you should do, or this is what you should think about. But of course, it's much more difficult to do it in real life and to actually begin to figure out how to go about gathering this information and capturing this information throughout your organization. And we wanted to give you a heads up about some of the common challenges that we've experienced when we've worked through this process. And these lessons learned are not just from working on CCPA efforts, but certainly going back to working with clients and attempting to figure out how to figure all of this out and get all the correct information for GDPR as well. And for those organizations that were working on information governance and data maps, although they were in the minority even pre-GDPR, these are some of the more important lessons learned. And, Mike mentioned that he has in-house experience, and I do as well. And I went through the painful process some years ago of trying to do a data inventory internally. So again, we know that this is not something that's really easy to do. But some of the things you want to keep an eye out for are listed on this slide. And I want to hone in on two of these bullets in particular. The second bullet, cultural, political, or bureaucratic barriers to collaboration and sharing, that can be a real showstopper when you're trying to gather the information. And the second to last bullet as well, inexperience in gathering, vetting, and consolidating the necessary information. So when you think about those things, it's difficult to, first of all, figure out how you're going to get everybody to play nice and provide you the information that you need. And some of you may have experienced this when you were working through GDPR questionnaires and GDPR data inventories. You would ask, can you please help me? Can you please fill this out? Can you please give me this information? And people would say, I'm too busy, or conversely, you would also find people who are very willing to participate and provide you information, but it's not the accurate information that you need, and it's not a comprehensive enough picture of what's really going on. So those are things that you just sort of want to keep in mind and think about.
If you've been to a conference recently in the privacy space, or if you haven't, you may have seen there are a lot of tools out there, a lot of vendors offering tools to do this kind of work. And so a lot of questions that we get are, look, I've done the questionnaire thing. It was hard. It was, the quality varied. Can I just automate this? It's a fair question. I could talk about it for a long time, but here's the bottom line. I think it goes back to the point about scoping. Develop a strategy, because you're going to see in your organization that there are times when the old-fashioned way, interviews and questionnaires, are the best way to get at this. And other times, a tool may be a great solution. And things to think about would be, how complex is this workflow? Maybe things are pretty simple, and you say, look, we don't need to go buy a whole tool and implement it and all that. We can get at what we need to do conversations. We've got knowledgeable people, systems people who understand the business, etc. Or maybe you don't, and you don't really have good people to talk to. Or maybe you've got very variable workflows. We've got 50 people in this department. There's a lot of independence. They do things a lot of different ways. Asking like the boss of this department how things are done is not necessarily going to get us there. Let's think of it. How do we bring in a tool to get a more independent view and see what's going on, whether that's a vendor or something we develop in house. Walking through a workflow, seeing what's getting stored on a server. There's no one size fits all. Unfortunately, there's nothing really yet, in my view at least, that's like plug it in and look across your environment. So again, scope, strategize, and figure out, we've got a toolbox here, and what tool do we want to apply in which areas?
All right, so I'm going to just sum up, and then I want to get to security, and I'm going to kick security off with a question from the audience. But all this sort of comes together with putting a project plan together, assess, create a gap analysis, do your data mapping, develop the notices, create and test the request management system, train personnel, implement the program, and continue to reassess and remediate. But now let's move to security, because that's the other prong of it. What is reasonable security? In fact, one of the audience members puts it best. I have a question regarding CCPA requirements when it comes to network security. I haven't seen any specific technical regulations dictating how systems, servers, network switches, etc., need to protect their consumer data. In short, there is no guidance. There is no guidance beyond what we already have as industry best practices, NIST, and Heidi and Michael are going to talk about some of that, but there is not a specific definition of reasonable security, and I think we're going to see that issue litigated every time there is a significant data breach. The class action bar, now with the lure of statutory damages and no need to show actual harm for standing, is going to argue that the breach is attributable to the failure to maintain reasonable security and therefore subject to the statutory penalties. So, Michael and Heidi, how do you help companies determine whether or not they've got a good story to tell when that litigation happens as to whether or not they maintain reasonable security?
Well, I think the word story is a good one, because it involves, in a sense, a narrative. So, if you're around this space at all for any length of time, you've probably heard, security is not check the box. It's a risk-based approach. And that's correct, although momentarily I'll have a caveat to that. But here's basically on this slide with the bubbles and equation here, that basically at a high level, reasonable security, and not talking for the moment about the law, what the law means, CCPA in particular, but just when you think about that as a security professional, it's about what are our risks, what do we have, what kind of systems, kind of data, things like that. How does someone want to attack us? And then what controls do we have to put in place, or what should we have that address each of those risks? And again, creating that story or narrative to explain how do the controls respond to the risks, then documenting what you have, and in particular, documenting what you don't have. So if there's something that, okay, here's a control we might have to protect this data, but we don't have it here. And that's because when we balance the difficulty of the user experience this would create versus the risk, which isn't that high, the balance is we really don't need this. And you have that documented, you can explain that, that's great. And that goes up to what I would consider, I think most people would consider a robust security program. But is it reasonable security under the statute? And we don't know that because, it's a legal question. And just because a security person would say it makes sense doesn't mean a judge or a jury would.
And so this is a question that's been asked for a long time, right? There's not a law that we can point to and say, well, this law says if you comply with this framework, then your security is automatically reasonable. But there are some established and accepted frameworks that have provide a strong baseline and have been accepted across the board, and many industries and sectors look to. For example, NIST, ISO, the CIS controls. As Mike mentioned, security is not check the box. You're going to have to be able to explain why you made a decision to implement or not implement certain controls. Like, for example, the NIST cybersecurity framework is very risk-based. It asks you to do a balancing test as you're doing your exam and as you're doing your assessment and you're deciding which controls to choose. But whatever you choose, you're going to need to have it documented and be able to explain it, because one thing we can be fairly certain about is that just saying, well, we did X, Y, and Z, but we didn't do a comprehensive risk assessment and we didn't align it with any particular standard will not likely pass muster for reasonable security.
Yeah, the take-home point I would say here is, it's not check the box, but don't throw out the checkbox because, for example, you have a breach of personal data, it's not encrypted. You may have a great explanation for that, but expect the regulator is going to say, why isn't it encrypted? Or how did the attacker get in with that two-factor authentication? Why was the shared account? Those types of things, they may be very well explainable. It may be reasonable in sort of a non-legal sense, but be prepared that the more your program sort of deviates from the checkbox, the better your explanations are going to need to be, because that's where a regulator is going to start most of the time.
Yeah, and I think it's worth noting that we like, when we work with you and others, we like to do it as an engagement at the direction of counsel. So as much of this assessment process can at least be arguably subject to the attorney-client privilege and part of the risk management decision making that we and you and the client have to make together. CLE code number 2, reasonable security. Please make a note of this so that you can get your CLE credit. And we've now come to the end of our presentation. We didn't get to all the questions that were submitted, but we will respond offline. So if you have any questions, feel free to put them into the box now before you sign off, and we will follow up with you directly. As I said, within a couple of days, you'll be getting confirmation along with a recording of the presentation, which you're free to share with your colleagues. It will have our contact information on it. So if you didn't get time to put a question in, but you want to follow up with one of us later, please feel free to. And we thank you all for your time and attention today.